Good day, Crime Talk aficionados. My name is Scott Reich, and this is Crime Talk. We have a big show for you today. First, the most recent school shooter and his dad appear in court. I guess one of those unique, novel prosecutions are taking place. You know, it was a bad toast by the groomsmen when the happy couple has to run the groomsmen over. Did Hunter Biden plead guilty because he wanted to avoid the embarrassment, or he was actually guilty? Or does he know he's going to get a pardon for an early Christmas gift? The judge jumper started trial and then pled guilty. A stepmom accused of killing her husband asked the kids to lie. Dismemberment by chainsaw, something you don't hear about every day, but a fine selection of machinery for sure. And then our dumb criminal of the day. Let's talk about it.
Hi, lawyer.
Good day, everyone. Thanks for joining us. You know the drill. Subscribe if you haven't, like if you do, leave me a comment below, hit that little bell for notifications. And yes, you can listen to us anytime on any of your favorite podcasting apps. All right, before we get to the docket today for September 6th, that's right, a word from our sponsor. First, ladies and gentlemen, go to crimetalksearch.com. All right. It is a background subscription service. And when you sign up for that background subscription service, guess what? You can do background searches on anyone here in the United States. And you get the results literally while you wait. You're going to get information as to their criminal history. If there's any divorce records, are there any public registries that they need to be on? You know, those little things that you want to check on before you start bringing new people into your life, ladies and gentlemen. Go to crimetalksearch.com, sign up for that subscription. You'll be happy that you did. All right, first, that's right, the most recent school shooter and his father made court appearances today. Now, as you may recall, the Georgia Bureau of Investigation has arrested the father of the 14-year-old boy accused of killing two teachers and two classmates at a Georgia high school on Wednesday. Now, Colin Gray has been charged with 4 counts of involuntary manslaughter, 2 counts of second-degree murder, and 8 counts of cruelty towards children after the attack on Wednesday. Now, his son, Colt Gray, has been charged with 4 counts of felony murder, and according to the police, more charges are expected. Now, Colin Gray reportedly told police that he had in fact bought the AR-style weapon for his son as a Christmas gift last year, and he bought it at a local store like most people would do, and it was for hunting. Apparently, the father even showed pictures of the hunting incident where he went hunting and killed his first deer, and he was very proud of his son. And his intent was to basically get his son interested in the outdoors, apparently, and get him away from playing video games. Anyway, like I said, that Christmas gift came a few months after law enforcement investigated the teen for online posts that threatened a school shooting. Investigators interviewed the younger Gray and his father, who told them that he had hunting guns that were locked safely away and that his son did not have unsupervised access to any of those firearms. Now, Colt Gray denied making any online threats, and investigators said they didn't find sufficient evidence for an arrest, and I would agree. That is not enough to arrest somebody. Anyway, the teen this Wednesday apparently opened fire at the Appalachia High School in Winder, Georgia, Wednesday morning. Like I said, killing the math teacher, Richard Aspinwall, and Christina Irmi, and 14-year-old students Mason Sher-Mahorn and Christian Angulo. 9 other people, 8 students, and 1 other teacher were also wounded. Now, the charges against the elder Gray are similar to those filed against the Crumleys. Remember James and Jennifer Crumley, parents of the Michigan school shooter Ethan Crumley? Ethan was 15 when he opened fire at that Oxford high school back in November of 2021, also killing 4 classmates and wounding 6 others. Now, Ethan Crumley pled guilty to all charges and was sentenced to life in prison. His parents were charged in what prosecutors described as a unique and novel theory of prosecution, the first time that a parent had been charged for a school shooting event. Anyway, they were convicted at trial, and they were accused of basically manslaughter in those cases for failing to get their son the help that he needed and buying him a gun that he in fact used in the shooting. They are both convicted, as I noted, and they received 10 and 15 years in prison in that particular case. Now, the father of the Georgia school shooter was quite upset when he appeared in court today for his first appearance, right after his son, Colt, learned that as a minor, he wouldn't be subject to the death penalty for the homicide charges. Now, the judge advised the older Gray that he could face up to 30 years in prison for each felony murder count, 10 years for each involuntary manslaughter charge, and cruelty to children. That's a total of 180 years. Now, ladies and gentlemen, no one's condoning school shootings. They're a bunch of cowards when they do this type of stuff. But if you go back and you look, and I talked about this in the Crumley thing, be careful what you wish for. They're coming. They're coming for more and more people, okay? Now, I know people are going to say, well, this guy shouldn't have bought his son a gun. He had issues. Well, what teenager doesn't have issues? Apparently, the young man was being bullied at school because he was gay. His dad was trying to get him interested in the outdoors. Do that manly stuff, I guess. Anyway, obviously the gun should have been locked up or something of that nature. But if, kids have hunting rifles, it's a thing in lots of parts of the country where kids can literally go out on their own and go hunting. So I got a real problem with the charge against the dad. Now, unless the dad basically said, son, today's the big day. We're going to go up there and shoot that school up, which I don't think he did. I don't think that he should be charged. But that's just me. But if we are going to have this kind of a civil negligent entrustment in criminal cases, parents, look out. It can reach to anyone. You lend your car to somebody, they go do something wrong. You give it to your kid, they go do something wrong, charge the parents. It goes completely against our criminal justice system, whereby we charge people for committing crimes that they committed, that they knowingly participated in. They knew it was going to take place, not speculation that you could have prevented this. Looking back, hindsight 2020. I know that may not be a popular view, ladies and gentlemen, but it's only going to get worse. Remember, I said every time a prosecutor tries a new, unique legal theory of prosecution, and they, for lack of a better term, get away with it, everybody and their brother is going to be doing it. And that's exactly what's going to take place. Let's just charge all the parents for everything that every juvenile does. Why stop at school shootings? How about the juveniles that robbed the car? Charge them. The juvenile that ditches school, charge the parents. I say bring it on. Be careful what you wish for, ladies and gentlemen. It's coming. Nowhere does the government ever try to cede power back to the individuals. They're going to do what they can to get the people that they want. And this is just one further step in doing it. Next, the groomsmen must not have given a good toast at this wedding, because a Michigan bride and her groom have been charged with running down and killing their groomsmen on their wedding day. That's right. James Douglas Schirra and his bride, Savannah Nicole Collier, and I guess Schirra, were celebrating their big day at a Flint, Michigan pizzeria on August 30th, when their groomsman, Terry Taylor, was later found dead with severe injuries from a crash, according to police investigators. So allegedly after the wedding, he was involved in an argument which led to him being intentionally struck by a large SUV that was traveling at a high rate of speed and driven by the groom. Now, Taylor later died at the hospital, according to the police, and police say that the bride and groom fled the scene, but were soon arrested. Now, Schirra has been charged with one count of second-degree murder, and the bride, she is being charged with accessory to a felony. The prosecutor did note that he's never seen anything quite like this in his 20 years as the prosecutor. Obviously he's seen people running over other people, but to do so soon after a wedding was a little surprising. I agree. Usually wait a couple of months, maybe the first anniversary, I guess. I don't know. Is there ever a good time not to run over the groomsmen? Yeah, let's never do it. Now, at their arraignments, they were each being held without bond, but bonds were set at $1,000 and $4,000, which they posted. Now, apparently, the groomsman was a dad of 3 and was expecting a 4th child with his fiancée. Don't get in fight with the groom, ladies and gentlemen. Don't get in fight with the groom. All right, next, Hunter Biden. We brought you this news yesterday. The trial for Hunter Biden was scheduled to begin the other day. And apparently, unbeknownst to the prosecutor or the court, Mr. Hunter Biden's attorneys said that Mr. Hunter Biden wanted to plead guilty and do an Alford plea. Now, an Alford plea is where you say, well, I'm saying I'm innocent, but I'm really going to plead guilty to avoid, in this particular case, the embarrassment of all the sordid details of Hunter Biden's conduct when he was a crack cocaine addicted individual. Well, since the prosecutors were a little surprised, they said, no, we're not going to do an Alford plea. So Mr. Biden said, you know what? I'll just plead guilty straight up because I am, in fact, guilty. And he pled guilty to 9 counts of tax fraud, ladies and gentlemen, 9 counts. It's almost like the man had no worries in the air. Sure, let me plead guilty to 9 counts versus if I'd pled guilty, maybe I would have only pled guilty to 1 count. But no, I'll wait till the morning of trial and do all 9 counts. Very, very unusual, ladies and gentlemen. Like I said, pled guilty to tax evasion to spare his family from the needless embarrassment of having to go through another trial and endure even more evidence of his seedy behavior while he was hooked on drugs. So now the twice convicted first son, like I said, unexpectedly pled guilty to the entire tax evasion case, which could land him behind bars for up to 17 years. He did this all right before the jury selection was going to begin. Now, it really makes you wonder, ladies and gentlemen, who's lying to who, right? Remember the whole Hunter Biden thing came out during the election, the laptop, and it was Russian disinformation, and those 51 people that worked for all the intelligence agencies said that it was Russian disinformation. And then we had the first trial in Delaware, and it turned out that the FBI knew that it was, in fact, Hunter Biden's laptop, and it was all legitimate, even though people got up and denied it. And people, including even the government, that knew that it was legitimate, and nobody corrected anybody. So for years and years and years, denied, didn't happen. This tax evasion stuff on money that he didn't pay taxes on because he was spending money out at strip clubs and on prostitutes and things of that nature. No big deal. Denied. Why are you all saying anything bad about the president's son? Anyway, like I said, Hunter Biden said it's more an invasion of privacy and the embarrassment. And he's put everybody through hell for the last couple of years because, like I said, the prosecutors had planned to bring in many people to testify in front of the jury about his crack cocaine addiction and how he paid tens of thousands of dollars for strippers and porn while dodging $1.4 million in taxes. And it would also explain where the money came from. Various foreign countries, like if you're not registered as a foreign agent. Anyway, guess what? It is what it is, right, ladies and gentlemen? We all have these types of issues come up. And like I said, the son of the now current president, I'm sure he has nothing to worry about. That's the only reason why someone would plead straight up guilty to 9 counts on the morning of trial, ladies and gentlemen, and not try to work a plea deal. You do that when you have nothing to worry about. Now, we did have the president say that he would not pardon his son Hunter for anything because he was in fact innocent, and obviously he was found guilty, and now he's pled guilty. So I guess the fix is in. We'll see. He's, like I said, he faces 25 years behind bars for the gun case in Delaware, and then the 17 years there in L.A. Now, do I think he's going to get all that time? No. Do I also think he's going to get a pardon as his dad leaves the White House? Absolutely, I do. Because, hey, the system works for everybody. There's no two-tiered system of justice in the United States, ladies and gentlemen. None whatsoever. None. It's fair to everybody. Hey, remember the jumper? The one that jumped the judge? Well, guess what? He also started a trial, and maybe he thinks he's going to get a pardon as well from the governor, because guess what? He's pled guilty. That's right. The trial of the man accused of leaping over the bench and attacking the judge in Las Vegas abruptly ended when the defendant decided to change his plea during the second day of trial. So after a scheduled court break, Deborah, D-E-O-B-R-A, Redden, R-E-D-D-E-N, he's a guy, pled guilty but mentally ill to all of the charges in his second amended indictment, which the judge accepted. Now, the state was willing to stipulate to allow him to withdraw his prior pleas of not guilty on counts 2 through 7, and he is going to face sentencing now on November 7th. Now, he was originally facing 7 charges, but pled guilty to all but 1 charge ahead of the jury selection, and he had pled not guilty by reason of insanity to attempted murder of a victim 60 years of age or older. Now, Redden has not reached any agreement with the prosecutors before pleading guilty. I'm sure he has a pardon lined up as well. Don't you think, ladies and gentlemen? Of course. Pled guilty in the middle of the trial. Next, stepmother stabs dad, asks the kids to lie. It happens all the time. So no one is disputing that Jennifer Nicole Heathcote stabbed and killed 33-year-old Taylor Rollins on the night of August 22nd at his apartment, where his children were at the residence at the time. But Heathcote has pled not guilty, and her lawyer has claimed that the defendant was in a tumultuous and violent relationship, leaving her feeling that she had no choice but to defend herself with a knife. Now, according to prosecutors, Rollins' 9-year-old daughter, who witnessed the stabbing, made the first emergency call about 7:40 p.m. Then, according to a transcript, the girl, while talking to the operator, said, quote, "My stepmom stabbed my dad." The conversation continued, and the daughter is heard saying, "Yeah, please come quickly. My dad is going to die." The operator asked where the children's stepmom is, and if she still has the knife. The child replied, "I don't know. I'm in my room." Well, the district attorney said that the suspect, Jennifer Heathcote, tried to get the girl to lie during the call. You can hear in the call what appears to be the defendant's voice telling the child calling on the phone to say that it wasn't her. Now, just seconds after that call, Heathcote herself calls 911, telling the operator that there was an emergency, saying, "Yes, there was just a little dispute, and I got you, baby. I got you. No, you're not. Breathe for me." According to that transcript, the operator asked Heathcote who stabbed Rollins, to which she responded, "Yes, ma'am. They ran out immediately." Anyway, kind of undercuts Miss Heathcote's claims of self-defense, but Miss Heathcote's lawyers say, hey, she was not the initial aggressor that night, and it was, in fact, self-defense. Miss Heathcote remains in a Mobile, Alabama jail as the judge has denied her bond. Preliminary hearing is scheduled for October 1. Dismembering by chainsaw. It's not what you hear every day, but I'm not saying go chop anybody up, ladies and gentlemen. Don't dismember. Don't abuse a corpse. Don't do anything like that. But we always hear about these people trying to dismember people, and it just gets messy. A chainsaw. That says, I am down to getting this done and getting this done quickly. So the ex-wife and friend of a Geneva County man who was dismembered by chainsaw in front of a 4-year-old child allegedly murdered by his lover is speaking out about the brutal crime. Now, this, too, also took place in Alabama. Geneva County deputies found Guzman's body dismembered in a car behind his house around Grady Garner Road and near Hinson Road in Fayette community on Tuesday, August 27th. Officers were called to the scene after receiving a missing persons report for a Mr. Guzman. Now, just one day after Jocelyn Lopez was charged with 1 count of intentional murder in the death of Benita Guzman, was in court claiming self-defense while also begging for freedom until trial. Well, the judge decided to keep her in custody. Alabama investigators say that Lopez shot Guzman 5 times and then used a chainsaw to dismember his body into 10 to 15 various pieces, and then wrapped his body parts in trash bags to put them in the trunk of the car as well as the back seat. Now, Ms. Lopez and her defense team claimed that the basis for the murder was, in fact, self-defense. Therefore, it was justified. And they also mentioned how Ms. Lopez and her family were threatened after Mr. Guzman supposedly owed someone money for drugs. Now, Lopez did have some bruising on her, but prosecutors say there was no evidence pointing fingers at Mr. Guzman for the bruises on the defendant. Now, needless to say, Ms. Lopez faces life in prison if convicted. So obviously it was self-defense, and she'll just need to plead guilty to the dismemberment. Okay, ladies and gentlemen, practice pointer here. If it is in fact self-defense, you immediately pick up the phone, call the operator, and say, I need to report a killing that was justified. It was self-defense. I was in fear of death or serious bodily injury. Please come get me. I'll be waiting here. The gun will be placed on the ground so the officers don't need to be afraid. I will be unarmed. Self-defense, ladies and gentlemen. Self-defense. And finally, our dumb criminal of the day. A Kenosha, Wisconsin man is accused of doing something very dumb. Police and prosecutors say that Demario Lavon Roy broke into City Hall on August 29th to charge his cell phone. This apparently was during the popular Peanut Butter and Jam concert, so there were a lot of witnesses. He was charged the next day with disorderly conduct and criminal damage to property. It is all about 5:16 p.m., and the police responded to a burglary call to the Kenosha Municipal Building. And when they approached the building, he was flagged down by an individual who pointed at the building and began running towards the east side of the building. Officers followed the man and discovered that he had broken a glass door to the building, hence the basis for the criminal mischief. Anyway, Mr. Roy charged criminal mischief, not smart. Lots of places you can charge your phone. A lot of places even have charging outside these days for the unhoused / homeless / people who just need to charge their phone. But Mr. Roy, you are a dumb criminal of the day. And everybody knows you don't commit crime. When the popular Peanut Butter and Jam concert was going on, there's too many witnesses, sir. Mr. Roy, you're a dumb criminal of the day. Congratulations. All right, everybody. I hope you enjoyed the show. Have a wonderful weekend. We'll see you next time on Crime Talk. And remember, yes, the Constitution matters.